This is CR Change Request. From the Sunday Desk, your structural brief for the week ending Sunday, July 12th, 2026. This week's read covers 9 signals across 4 movements. Before we open the board, hold one idea because it runs underneath everything that follows. This week isn't really about control moving. It's about power routing around resistance. When an order gets blocked, when a bill stalls, when lawsuits fail, the effort doesn't always end. It changes shape. It moves into the quieter instruments. A commissioner removed. A grant condition attached. A warning letter sent. A rating rule rewritten. A public record allowed to fade. Each one starts producing pressure before anyone's finished arguing about whether it's legal. So the anchor for this week is the conditions of control, and the discipline is to watch them get assembled while the courtroom fight is still going on. We're starting where the pressure is highest, with elections, because 3 separate headlines this week are actually one movement. On the surface, you've got 3 developments. The Election Assistance Commission, the small federal body that supports election administration, was left without commissioners. Its staff can continue routine work, but without commissioners and a quorum, the commission can't take up new policy or approve changes to voting procedures and the National Mail Voter Registration Form. Separately, FEMA told states it'll hold back 20% of homeland security grants totaling just over $1 billion until they satisfy a new set of election requirements. And the Justice Department sent letters to all 50 states and Washington, gave them 5 days to answer, and warned election officials that they could face criminal liability tied to non-citizens on the rolls. Covered one at a time, they look like 3 stories in 3 different agencies. They're not. They're the 5th move in a campaign that's about 18 months old. And once you see the sequence, you can't unsee it. It started by stepping back. Early in 2025, the federal government pulled away from helping states defend their election systems. It stopped monitoring election disinformation, cut personnel who tracked foreign influence, and ended support for the threat-sharing network states had leaned on since the last major round of election interference. The shield came down first. Then came rule by decree. A March 2025 executive order tried to require documentary proof of citizenship on the federal registration form, move against late-arriving mail ballots, and threatened funding for states that didn't comply. It was challenged within weeks, and major parts of it were blocked. Then came the demand for data. The Justice Department began asking states for their full, unredacted voter rolls, including sensitive personal information, to run against a federal database. About 18 states complied. 30 states and Washington, D.C. refused, and the department sued. Then it lost. And then it lost again. Every judge to reach the question turned the department down. That record now stands at 11 losses in the district courts, and its first loss on appeal. Not one court has ordered a state to hand over its unredacted voter rolls. It's worth saying, because it's the fact the theory keeps colliding with, that audits and studies have consistently found non-citizen voting to be rare. That accumulated resistance is the counterforce. And I want you to keep it in the room because it's the part the headlines flatten. Courts blocked the citizenship directive. They rejected the voter data theory. They'd already blocked earlier attempts to use homeland security grants as leverage, including immigration enforcement conditions and a separate grant reallocation. The legislative route stalled in the Senate. The front doors, one by one, were closed. And that's exactly when the instruments changed. On June 24th, FEMA published the new grant conditions. 5 days later, in Trump versus Slaughter, the Supreme Court overruled Humphrey's executor and widened the president's authority to remove commissioners from independent agencies. The White House then cited that ruling when the Election Assistance Commission commissioners were removed. Within 2 weeks, the letters went out to the states, and the commission was left without a quorum. Decree, then legislation, then litigation, then coercive administration. Each time one route closed, the effort moved to a route that was harder to stop. So, what's each new instrument actually reaching for? The structural effect of emptying the election commission is that the body positioned to approve or resist changes to the national registration form can't take up new business. That matters because proof of citizenship was one of the changes administration officials have been pressing the commission to adopt. The grant conditions reuse a funding lever that courts have already limited in other contexts, now with election administration as the condition. And the letters take a voter data demand judges keep rejecting and convert it into prosecution risk that needs no judge at all. There's a paradox sitting at the center of this, and it's worth saying plainly. The same government that stepped back from protecting elections is now pressing hard to shape how they're run. It took the shield down, and now it's conditioning that same category of security money on election compliance. The words election security were used to justify both the retreat and the reach. And if you want to know how this lands on the ground, listen to the officials receiving it. Utah Lieutenant Governor Deidre Henderson, the state's chief election officer, described receiving another love letter from the Justice Department, accompanied by threats of criminal prosecution. She's a Republican election official describing the pressure coming from a Republican administration. These are career administrators, many of them nonpartisan, being told they've got 5 days to explain themselves. That's what pressure looks like before a single charge exists. Because here's the mechanism the whole cluster runs on. It works on timing, not on winning. A funding condition changes what a state budgets for months before any court can rule. A prosecution warning changes behavior before an indictment is ever drafted. A commissioner is gone the moment the email lands, no matter how the case eventually comes out. The instruments are built to work in the gap between the action and the ruling. When the front doors close, power doesn't stop. It looks for a side entrance no one has locked yet. So if you operate anywhere near this, the next few weeks turn on a short list of questions. Whether states challenge the FEMA conditions before the late July deadline, whether a commission with no commissioners can conduct any new business at all, whether the Justice Department follows its letters with subpoenas, investigations, or criminal referrals, or lets them sit as pressure, and whether Congress moves to restore the commission's capacity or stays outside the fight. The rulings so far have narrowed the routes. They haven't ended the search for new ones. That same move, changing the rule instead of winning the argument, shows up next in 3 very different rooms. Let's start with how the federal government grades its own workforce. The Office of Personnel Management finalized a rule this week that rewrites federal performance appraisals. It removes the prohibition on standardized rating distributions and gives OPM authority to establish them. It eliminates the level 2 minimally successful category, ends mandatory higher level review before an employee is marked unacceptable, and removes ratings of record from negotiated grievance procedures. On its face, the pitch is accountability. Too many top ratings, not enough honest difference between them. So, why rewrite the scorecard now and not later? Because timing is the point. There's a separate proposal still pending that would prioritize performance over tenure and length of service when agencies decide who remains during a reduction in force. Set those two next to each other. One rule redesigns the scorecard. The other could give that scorecard greater weight in deciding who survives a workforce cut. The scorecard is being rebuilt before the proposed layoff system that could use it is settled. And if you're a career federal employee, you already feel the ground shift. The question was never whether your rating makes you feel appreciated. It's whether a number that's become harder to contest later becomes the number that helps decide your job. The structural point isn't the grade. It's that a centrally supervised rating system may become a future workforce selection mechanism, and the pathways for pushing back are narrowing at the same time the stakes are rising. That brings us to a quieter change with a longer reach. Across several agencies, the government has been rewriting its civil rights regulations to remove what's called disparate impact liability. In plain terms, that's the principle that a facially neutral policy may be challenged because it produces a discriminatory effect, even without separate proof that the decision maker intended that result. The State Department's version took effect this week, and it sits inside a broader sequence running through justice, labor, commerce, homeland security, transportation, agriculture, interior, and other agencies. Now, notice what didn't change. The agencies didn't stop collecting outcome data, they kept it. What moved is what that data is allowed to prove. Before, a facially neutral policy could be challenged for producing a discriminatory effect without separately proving intent. Now, the same pattern is more likely to serve as evidence pointing toward intent, and the person bringing the claim has to prove more about the decision maker's purpose, not only the result on the ground. The data stayed. The legal meaning assigned to it changed. And in the same stretch of days, the Equal Employment Opportunity Commission rescinded guidance it had maintained since 1979, the framework employers used when they wanted to take voluntary corrective action to address a documented imbalance in their own workforce. The law against employment discrimination is still on the books. What went away is the EEOC's long-standing framework for employers attempting voluntary corrective action without a formal finding of intentional discrimination. Connect those two, but don't collapse them. One narrows effects-based enforcement for recipients of federal funding. The other pulls back the guidance for voluntary employment correction. Together, they mark a retreat from tools built to address inequality that accumulated over time, the kind you usually can't trace to one deliberate act or one identifiable decision maker. And the people who feel this first aren't in a courtroom. They're in a hiring office or a compliance shop, looking at their own numbers and realizing that the framework they were told to follow has been pulled away, even though the duty to comply with civil rights law hasn't moved an inch. Now, this next movement looks smaller, closer to the ground, but it carries the same question about what an agency can do after a court has already told it no. 15 states went to court this week to stop the Department of Education from ending grants that place mental health professionals in schools, the grants Congress funded after Parkland and Uvalde. What makes this one structural is a single word. A judge already blocked an earlier attempt to end this funding back when the department called the action a discontinuation. The department has returned and called the new action a termination. The states argue the operational result is identical and that the new label is doing the work of getting around the court order. Said plainly, the fight is whether changing one administrative word allows the department to reach a result the states say the permanent injunction already bars. And underneath the vocabulary is a school counselor who doesn't know whether the job exists in the fall, and a student who was finally getting somewhere with someone they trusted. The label is administrative. The empty chair in the building is not. The second signal in this movement comes out of Baltimore, and it complicates the easy story. The city's state's attorney called Maryland's juvenile justice system broken, top to bottom, and asked for more investment, more programming, and more treatment capacity. So far, that sounds like a prevention argument, but that's not the whole of his position. In the same breath, he asks for more detention authority, longer timelines in serious cases, more discretion handed back to judges, and changes to the recent limits on how young people may be charged and prosecuted. He's not offering services instead of enforcement. He's asking for both at once. And that's the tension worth holding. Upstream, states are in court defending prevention. Downstream, a prosecutor points at the same failing structure and asks for more services and more coercive authority in a single motion. A broken system can produce agreement about failure without producing agreement about the remedy. When support fails upstream, enforcement inherits the crisis downstream. The last signal is the quietest of them all, and it's quiet by design because it's about the record itself. On July 22nd, the Federal Communications Commission is scheduled to vote on a draft report and order changing the broadband label rules, the nutrition style boxes that are supposed to show what internet service really costs. The Commission's stated case is simpler labels and lower compliance burdens for providers. But the structural story isn't only the label a customer sees today, it's the record behind it. The draft would drop requirements that providers maintain this pricing information in machine-readable files, stop requiring them to archive labels for plans they've retired, and loosen the trail researchers, regulators, journalists, and consumer advocates use to reconstruct how prices change over time. Put differently, the question isn't only whether a household can read this month's bill. It's whether a researcher, a regulator, or a reporter can go back in 2 years and prove how the prices actually moved. A bill can stay perfectly visible while the institutional memory behind it quietly thins out. Transparency isn't only what the customer can see today, it's what the watchdog can reconstruct tomorrow. So the things to track here are narrow and concrete. The July 22nd vote itself, whether any machine-readable reporting survives in the final order, and whether consumer groups challenge it after publication. So step back and read the whole board. 9 signals, and one method underneath all of them. Personnel removed. Funding conditioned. Enforcement threatened. Standards rewritten. Records thinned. Different agencies in different sectors, but the same administrative route. An election commission left without the governing capacity to take up new business. Grant money held back until states adopt specified election practices. Prosecution letters standing in for a legal theory the government keeps losing in court. A performance system rewritten while a separate proposal would give those scores more weight during workforce reductions. Civil rights standards narrowed while the data beneath them remains in the file. A decades-old framework for voluntary correction withdrawn. A funding termination relabeled while states argue the outcome remains prohibited. A prosecutor asking for services and greater authority in the same breath. And the broadband record allowed to thin out precisely where watchdogs once had the ability to look. Different agencies, different sectors, one method. Put it together, and the operating structure is doing something specific. It's moving largely through tools that don't require a new act of Congress. Personnel the executive can remove, conditions agencies can attach, letters departments can send, standards regulators can rewrite, records institutions can stop preserving. These instruments run on timing. They produce effects while the argument about their legality is still unfinished. That's the through line, not consensus. Instrument. And if you carry one thing out of this week, let it be the election cluster, because it shows the method at full strength. Courts blocked the order. Judges rejected the data demand 11 times over. States refused, and they won. And still, the effort didn't stop. It moved to the money, to the letters, and to the empty seats on a commission. The resistance is real, and it's holding in the courtroom. The instruments are simply built to move faster than the courtroom can. Most of this didn't require a new statute. It changed how existing authority is being used. So take this into your week. Watch the instrument, not the announcement. When a headline tells you what was decided, look underneath for the tool doing the actual work. The removal, the condition, the letter, the rule, the record. That's where the read is. That is the brief for today. Good to be in the room with you. Until next time, this has been CR Change Request.